All right, let's dive straight into this explainer. We're unpacking the Indian Contract Act of 1872 today, taking all that intimidating legal jargon and translating it into something much more relatable, the actual life cycle of a promise. Whether you're signing a commercial lease, accepting a massive job offer, or, just clicking I agree on some new software update, you're stepping right into the world of contract law. So, we're going to trace the fascinating journey of a contract from the very second it's born all the way to the moment it legally dies.
Here's our roadmap for the journey. We'll kick things off with how we actually fulfill promises, navigate through the messy stuff like joint liabilities and reciprocal payments, explore what happens when things inevitably go wrong, and finally, look at how to safely discharge an agreement.
Okay, starting with Part 1, fulfilling your contractual promises.
At the absolute heart of contract law lies this classic Latin phrase, pacta sunt servanda. It's basically the philosophical anchor of our entire commercial legal system. It literally just means that agreements must be kept. When you enter into a lawful contract, there is an ironclad expectation that you are going to honestly fulfill your promise. Without this, well, commercial trust would just collapse.
So, legal performance is the ultimate goal here. Under Sections 37 to 41 of the Act, when you do exactly what you said you were going to do, boom, you are completely discharging your obligations. It's the cleanest, most natural way for a contract to end. But what happens if you try to perform and the other guy just won't let you?
Right, that brings us to attempted performance, or what the law calls a valid tender. Let's say you show up with the goods, ready to deliver, but the buyer just refuses to accept them. Well, as long as your offer to perform hits these strict criteria, meaning it's unconditional, it's the right time and place, it covers the whole obligation, and you're truly ready, the law says it has the exact same legal effect as actual performance. You're entirely protected and your rights are preserved.
Now, usually, you can perform the contract yourself, or you can just have an agent or a third party handle it for you. But there is a massive exception: personal contracts. Think of the historic case Robinson versus Davison. If a contract relies entirely on personal skill, like say a famous artist hired to paint a portrait, and that artist suddenly falls ill or dies, you can't just pass the gig on to their cousin. The law completely discharges the contract right there because that specific personal skill is gone.
Moving on to Part 2, joint liabilities and strict timelines. Look at this number, 100%. If you and a business partner take out a joint loan from a bank, you probably think you're only on the hook for your 50% share, right? Well, actually, no. Under Section 43's principle of joint and several liability, the bank can legally compel either one of you to pay back 100% of that promise. The bank is heavily protected here. Now, sure, if you end up paying the whole thing, you have a right of contribution to sue your partner later for their half. But as far as the bank is concerned, you are on the hook for the whole shebang.
And then we have the ticking clock. If your contract doesn't explicitly state a deadline, Section 46 says you just have a reasonable time to get it done. But things escalate fast under Section 55 if the contract specifies that time is of the essence. Now, in real estate, they usually don't strictly enforce exact timing. But in fast-moving commercial deals, missing a tight deadline by even a little bit allows the aggrieved party to completely tear up the agreement and demand compensation.
Let's look at Part 3, reciprocal promises and payments.
This distinction right here really dictates the flow of everyday business. Most commercial contracts are bilateral reciprocal promises, meaning my promise is the consideration for your promise. But under Section 54, if someone fails to do their required first step, it changes everything. Think about it. If you hire a builder but don't give them the approved architectural designs first, they are entirely excused from starting work. You can't demand they build the walls when you haven't given them the blueprint for the foundation. And actually, you'd owe them compensation for the delay.
Which naturally leads us to what happens when money finally changes hands, but things get a bit messy. It's called the appropriation of payments. Say you owe a bank a 10,000 rupee principal loan plus 5,000 in interest. Who decides where your payment goes? Under Section 59, you, the debtor, have the power to specify. If you stay silent, Section 60 gives the power to the bank. And if neither of you says a word, Section 61 kicks in, relying on the famous precedent from Clayton's case, and the law automatically applies your money to the oldest debt first.
Okay, Part 4, when things go wrong.
Understanding your rights during a breach is absolutely crucial. An actual breach is super straightforward. They promise to deliver on Friday, and Friday comes and they don't. But what if it's only Wednesday, and they email you saying they absolutely aren't going to deliver on Friday? That is an anticipatory breach. It's a powerful doctrine recognized in the landmark case Hochster v. de la Tour.
The incredible thing here is you don't even have to wait around for Friday. The law lets you terminate the contract immediately and sue for damages right then and there.
But what if they didn't break the promise on purpose? The general rule is you absolutely must perform, but the ultimate escape hatch is Section 56. This is the doctrine of impossibility, often called frustration. It applies when some unforeseen, catastrophic event makes performance physically or legally impossible, completely destroying the foundation of your agreement. When that happens, the contract immediately becomes void and everybody gets to walk away. It is incredibly important, though, to understand the limits of this doctrine. Historic cases like Taylor v. Caldwell show us that if the concert hall you rented literally burns to the ground the night before the show, yes, you are excused. It's physically impossible. Same for an outbreak of war or a sudden government ban. However, and this is a massive however, this does not apply to mere commercial hardship. If raw material prices suddenly triple and you're bleeding money, too bad. That's not impossible. It's just unprofitable. You are still legally bound to perform.
Finally, Part 5. Discharging contracts by mutual agreement.
Sometimes the absolute best way to end a contract is just to create a brand new one. Under Section 62, novation lets you swap out the old agreement entirely. When you do this, the original obligations are completely wiped off the map. This is incredibly common in business because it even lets you bring in entirely new parties to take over a debt or a service. But hey, maybe you don't want to tear up the whole document. If you just want to make a few tweaks, alteration allows you to modify the rules of your existing agreement. As long as everyone mutually consents, the original contract just keeps rolling along in its newly altered form. Or, sometimes a deal just isn't working out for anyone involved. In that scenario, you can literally just agree to walk away. This is discharge through rescission. By mutual agreement, the contract is officially canceled, and the legal goal is to restore both sides to the exact positions they were in before the promise was ever made.
The Act also gives us incredible everyday flexibility under Section 63. It empowers a creditor to amicably settle disputes without needing some fresh, complicated contract. You can just dispense with the performance completely. Or, through remission, you can accept lesser performance, like taking $8,000 to fully settle a 10,000 rupee debt just to get it off your books. You can also formally grant an extension of time, which essentially suspends your right to sue them, keeps things out of the courtroom, and just keeps commerce flowing.
And beyond the standard defaults of the law, modern businesses proactively write their own exit doors straight into the fine print. Think about force majeure clauses that act as a pre-agreed shield against massive acts of God. As we've seen in cases like Energy Watchdog, these carefully drafted cancellation clauses ensure real commercial predictability. They let parties terminate obligations automatically when specific triggers happen, perfectly respecting the ultimate freedom of contract. So, we've seen how a promise is born, how it navigates the messy hurdles of reality, and exactly how the law allows it to finally end. After journeying through all this, I'll leave you with a thought about your own current agreements. Look at the contracts you're bound to right now. Which exit strategy, performance, impossibility, or agreement are you actually banking on? Let's definitely hope you're aiming for full performance rather than waiting around for a burned-down concert hall. Thanks for diving into this explainer with us.